This afternoon, at long last, it is here. A frenzied week of legal reckoning for Donald Trump, circled in red Sharpie on our calendars for months. At hand, a cascade of major in-court moments for the disgraced ex-president, where he'll finally experience consequences for some of his actions. Next week, Tuesday, marks the beginning of the second E. Jean Carroll defamation trial. News on that to tell you about a bit later on. But first things first. Developments late this afternoon ahead of closing arguments. Tomorrow in New York's $250 million civil fraud lawsuit. A short time ago, Judge Arthur Engoron revealed he would not allow Donald Trump to deliver part of those closing arguments himself, as he'd requested. The reasoning, neither Trump nor his attorneys ever got back to the judge, agreeing to preconditions. In truth, it is hard to imagine what Trump wanted more. An opportunity to put himself at the center of the proceedings, to deliver his message in his own way, or an opportunity like this, to complain, to whine about being silenced, despite the fact his own team failed to respond to the judge on time. Now, remember, in both cases, E. Jean Carroll's defamation and New York civil fraud, Trump's guilt has already been determined. So these decisions will only settle the punishment. And on top of that, this afternoon, at any moment, perhaps we could hear back from a three-judge panel on the topic whether or not Trump is immune from prosecution on charges that he plotted to overturn the results of the 2020 election. So, as expected, here we are on the doorstep of a chaotic period for Donald Trump and ultimately Americans at large. And that is where we start today with former Deputy Assistant and Attorney General and former U.S. Attorney Harry Litman. Plus, with me here at the table, MSNBC legal analyst Lisa Rubin and New York Times investigative reporter Sue Craig. Harry, let's take this just piece by piece. First, I want to read the preconditions that were set out by Judge Engoron. Quote, he may not seek to introduce new evidence. He may not testify. He may not comment on irrelevant matters. In particular, and without limitation, he may not deliver a campaign speech, and he may not impugn myself, my staff, plaintiff staff, or the New York State court system, none of which is relevant to this case, and all of which, except commenting on my staff, can be done and is being done in other forums. Engoron went on to outline time limits, suggested he would interrupt Trump if warranted, committed to fining Trump if he violated the terms of his gag order. Harry, first and foremost, these conditions, fair or unfair?
Totally unfair. Normally go without saying, Alicia, but it's just with him. You cannot leave the unsaid. It just what it means is stick to the evidence. That's what happens at closing arguments. You give a summation. You explain why your side should either prevail or do well. And it was evident that Engoron had to do something about Trump, and they never got back to him. By the way, not just late. He set a deadline of Wednesday, then Thursday, and it was clear he wasn't going to commit to this. He wanted to give a kind of campaign speech. And so Engoron shot him down. Nothing at all untoward about the conditions.
Okay, Harry, there was a lot of email traffic here. Judge Engoron, he rejected Trump's request to be a part of the closing arguments after his team failed to agree on those preconditions. So let me read you some of the email exchanges between Judge Engoron and Chris Kise, attorney for Donald Trump, sent this morning just before 11 a.m. Dear Mr. Kise, as I have already indicated to you, if Mr. Trump wishes to speak, you will have to tell me now that he will agree to the limitations I have imposed, which go without saying and apply to everyone, as you just said, Harry. And he will have to agree to do so tomorrow on the record, which should take no more than a minute or two. Then, 40 minutes later, the response. This is very unfair, Your Honor. You are not allowing President Trump, who has been wrongfully demeaned and belittled by an out-of-control, politically motivated attorney general, to speak about the things that must be spoken about. 14 minutes later, from Judge Engoron, I won't debate this yet again. Take it or leave it, now or never. In all caps, you have until noon, 7 minutes from now. I will not grant any further extensions. Then the follow-up from Engoron, 12 minutes after noon, quote, not having heard from you by the third extended deadline, noon today, I assume that Mr. Trump will not agree to the reasonable, lawful limits I have imposed as a precondition to giving a closing statement above and beyond those given by his attorneys, and that, therefore, he will not be speaking in court tomorrow. I mean, only so much opportunity Judge Engoron can provide here, Harry.
It's true. And actually, this really has the earmarks of Trump himself. That one statement from Kise, it's very unfair. He's being railroaded. He needs to say things. That's a page out of his normal stump speech. And you can bet there would have been more such pages. And after all, what else would Trump be wanting to do other than deliver that? And the one thing that Kise was saying is everyone's going to keep him on a short leash, because as soon as he started to violate, one warning, $50,000, et cetera. So he was going to keep that from happening. So it's no surprise that they couldn't accept it. It's a bit of a surprise they never even had the courtesy to respond and say no. But you understand exactly why the judge did this here. And it tells you exactly what Trump wanted to do. And what he wanted to do is not proper.
Right. So this fits right into the Trump playbook, right? Act as though you are somehow the aggrieved.
Right, the victim, which is a familiar storyline we know with Donald Trump. He's been playing it since he's been in his 20s. So I think we saw this train coming down the track. As soon as I heard the other day that he wanted to speak in the closing arguments, you knew this was going to be a circus and there was going to be objections. And this was a stunt, I think, to get a lot of seats in the courtroom tomorrow. Donald Trump wants eyes on this, and the best way to do it is to say, I'm going to show up. He did the same thing a few weeks ago. He said he was going to show up, and he did, and then he decided at the last minute not to testify. And that created a lot of chaos just the night before, and people made plans to go down. He wanted media attention on it. I think this was the exact same. And you also look at this, Harry made just a great point that, you know, I've got a copy of the email exchange, and even the typeface is different on some of them, as if they were cut and paste, like as if Chris Kise didn't write them and they were sent to him. Like, it's a very odd several pages of emails, I have to say. It looks like somebody, maybe, I don't know if it was Donald Trump or somebody with Donald Trump, sent, you know, here's what Chris should say, and it was cut and paste into the email. I
always do love a formatting issue. It always is a tell. This also reminded me of when you were in court and he testified. We could just sort of rewind to that moment, because in some ways I think that performance was a tell about what we could expect had he somehow actually taken this opportunity here.
Absolutely, because he was unrepentant. He talked about things that were far outside the scope of this case. He really just wanted an opportunity to explain himself, and he could not believe, he could not grasp, Alicia, that Judge Engoron would rule against him without knowing him. He was affronted that Engoron wouldn't take the opportunity to get to know him, and he was pointing at him, you know, sort of doing the Alec Baldwin-esque point. He doesn't even know me. He was so insulted, and the rage was not helpful for him in any way.
But help me understand, which is, if your idea is that you want to somehow ingratiate yourself to the judge, if you're making
but he doesn't.
But then, right, because then to attack the judge, to attack the judge's clerk, it doesn't all fit together.
This was never about making an argument about winning the case. It was, as Sue said, getting bodies in chairs. And let me be very clear with you and our viewers. Sue and I were scheduled to be there. We would have been there irrespective of whether Donald Trump showed up or not. But there are other people in the media who follow this maybe more tangentially than the two of us do. And they will make decisions about whether to get their bodies into the courtroom based on their perception of what theatrics are going to unfold before them. So part of it was getting bodies in chairs. Part of it was ensuring that he could fundraise off of a new grievance, right? Because all of these court appearances have been successful for him from a fundraising perspective. And it was also about just being able to complain, like a new wound, a new grievance that you can use as a cycle for new social media posts. You know, the one thing that I think is also really interesting, Alicia, about this email exchange that I want to point out is how it starts. Because we talked about how it ends, right? It turns very Trumpy at the end with wording and phrasing that doesn't seem like Chris Kise, even capitalizing the word mother-in-law, which is like straight out of Trump's social media post style guide, so to speak. But it starts with Chris Kise wishing the judge and his law clerk, who he has talked about ad nauseum in fairly graphic and not complimentary ways, wishing them a happy new year and signing the email, Chris. There's an informality going on here in this proceeding because these people have lived with each other for weeks. but also because it's a state court proceeding. None of this would ever be happening in the federal courts that Harry and I have practiced in. There would be no email. There would be no dialogue like signing things Chris as opposed to respectfully Christopher, whatever his middle initial is, Kais. None of this would be happening in a federal court. And we saw that yesterday when Trump went to D.C. for the D.C. Circuit argument. He could not transform the federal court complex in D.C. into his personal theater the way he's been able to turn 60 Center Street downtown into his constant
vehicle
did have the weather
for
the Trump show.
Him, but yeah, you're right.
No, but it hasn't been allowed. There are no cameras there. There's no press conferences there. And so this, for Trump, is sort of one of his last opportunities for some time to come, because next week when the Carroll trial comes, it will be much more akin to what happened yesterday than what we're expecting to happen tomorrow.
Do you think he really wanted to testify? Do either of you think he really wanted to testify?
No.
No, I think it was a stunt. I mean, you made a good point the other day about, or another day, just a moment ago, just about the, who is he speaking to? I mean, he's just going to enrage the judge by doing this. He's already lost this. And they're not only reaching into, there's going to be an appeal of this, but he's speaking to the people in the bleachers. This is about his base. It is about fundraising, all the things Lisa mentioned. It is not about winning an argument.
Can we go back to something you said? You asked, did he really want to testify? And I'm not sure whether you were talking about the decision he made several weeks back not to testify in his own defense, or whether we're talking about tomorrow when he wanted to participate in arguments.
Yes.
Okay. So the idea of a defendant or any civil litigant participating in their own closing argument, if they're represented by counsel, Harry and I can both tell you I've never seen that happen. And indeed, in the email exchange, it's very clear that based on the case law, no defendant or other party has a right to get up and offer their own closing arguments. You have to choose. You either have a lawyer or you go at it by yourself, pro se. And otherwise, if you want to speak, it's solely at the judge's discretion. I cannot understate I cannot overstate how rare it would be for any litigant to get up in his or her own defense in a civil or even a criminal litigation where they otherwise have competent counsel. And despite the fact that Trump is putting words into Chris Kiss's mouth, I want to assure people Chris Kiss is competent counsel when left to his own devices.
Great.